Well, welcome everyone. We welcome you to this educational forum. It is on ADA issues, compliance issues for businesses. And we put this on to respond to some recent issues as well as obviously long-standing issues with our disabled people in the community about access, getting around town and in businesses. And our local businesses have been wanting information on what the laws are, what they need to do to make their businesses accessible. And so that's the purpose of tonight's forum. We have Gary Waters here, who is an architect and certified access specialist from Santa Rosa. And he has many years of experience working on accessible projects and working with business people as well as disabled people. This event is co-hosted by the city and by the Chamber of Commerce. Lisa Epstein, the Chamber President. And we have a few people we want to thank tonight. Obviously the Chamber of Commerce for partnering with us once again. Printing Plus, Tim Ramming, is always wonderful to work with, and he put together the postcards announcing this event and also distributed them around town. So thank you, Tim. Bechtel Creek Inn and Scoops Deli, both supportive of getting this event put on tonight. And I have to give a big shout out to John Sherman. He's done a tremendous amount of research on the issues and trying to be responsive and making contact with our presenter. And so thank you, John, for your efforts always. And then Lisa, I don't know if you wanted to add anything?
Yeah, I have a couple things.
Okay, good.
Yeah, I wanted to thank you, thank the city for partnering with us. It's always great to feel like we're collaborating, and I think we're so much more effective when we do that, so thank you. Thank you, Gary, for being here. And thank you to Lisa Davis at Scoops. I mean, you already thanked Buzz, I was going to, but I'm doing it anyway. Tim Ramey, thank you for everything you've done to make this happen. This wouldn't have, I don't know if it would have happened as soon as it did, and if it weren't for Tim's efforts, so we're grateful to him. Adrian and John. And then I wanted to thank our Chamber President Circle members as well. They are a huge supporter of the Chamber, and without them, we would not be able to do a lot of things we're being able to do this year. And those sponsors are Frank R. Howard Hospital, Metal Effects, Bechtel Creek Inn and Spa, Super 8 Willits, and Spare Time Supply. And I wanted to say one other thing. Save the date for March 15. I'm going to plug, we're going to work with West Company. It is going to help us bring a seminar here, Claim Your Google Listing. And so any business that has not claimed their Google listing yet, whether you're brick and mortar or not, you can have a listing, and if you haven't claimed it, it's important to do that to get you on the map. And this workshop's going to be a hands-on. We're going to have 2 sessions, a 3 o'clock and a 6 o'clock. The 3 o'clock is for restaurant people who maybe can't come at 6, and the 6 o'clock is for people who maybe can't come at 3. So stay tuned, that's March 15. We'll get you more information, and it's going to be a workshop where you're going to do it right there.
I just want to say one more thing. This is an unprecedented time for Willits. We had the bypass open on November 4th, I believe it was, and so we are, 3 months, almost 4 months into it, and it has definitely had an impact on our community. We believe that this will be the toughest part of it, that we will, improve. But our businesses are challenged right now, and so we want to support each other, and we also want to support everybody that uses our businesses, our residents, our visitors, and our disabled citizens are very much a part of this community, and so this community has to work for everyone. And we're trying to address that in a lot of different ways, from how to market our community and our businesses more effectively, to making improvements on Main Street. And this is a key component, is making sure our community is accessible for all that want to enjoy it. So with that, I'd like to turn this over to our presenter, Gary Waters. Thank you again for being here.
Thank you. Well, so this presentation is mainly geared toward business people, and hopefully it'll give you answer some questions. So I wanted to start with kind of some of the myths about access and some of the misconceptions that that we have, that I've heard over the years, to see if any of these things apply to you, or, you know, is what you're thinking. Maybe hopefully we could answer some of these and go through why these are misconceptions. But the first one, and I hear this a lot, is I'm an existing business. Aren't I grandfathered? Don't I have some exception because I haven't done any construction for 20 years? So that is the first one. I don't have to worry until I do construction. I hear that a lot, is that access must be triggered by me doing something, and that's not true. That's not the case. Number 3, my facility was built with a permit and should be fine. And that is one of the reasons I'm in business, is because that's really not the case. Although we've had access requirements in California since 1974, I believe, back that far, with, you know, they were pretty minimal at that time, and they weren't in the building code at that time. That really haven't been starting to be enforced a lot in buildings and in the permitted construction until recently, within the last 10 years. That happened, and probably the biggest change starting about 2008, when California enacted one of the laws we'll be talking about later in the presentation, that said local building departments have to hire a certified access specialist, or have one, or contract with one by a certain date to start enforcing and having, you know, making sure access is dealt with. So that's when I start seeing access at the building and construction level, the permit level, starting to take a bigger focus in building permits. But that leaves a whole lot of building history in California when it really wasn't focused on very well. The next one is I'm not open to the public. So while if you're not open to the public, your risk is going to be less. It's not going to be eliminated. The ADA talks about other things besides just your physical construction, physical accessibility. There's also policy and procedure issues, and how you relate to the public or your customer base by the internet, those kind of things. So those could also come to you in a lawsuit at some point. Number 5, I can fix the issues once I get sued. Much more expensive to fix things when you get sued, because if you lose in a lawsuit, you get to not only fix the items that need to be fixed, you get to pay for your attorney, the plaintiff's attorney, and damages, as well as the injunctive relief for fixing the problems. And in California, each item can be up to $4,000, and often a plaintiff expert can find many items or barriers at a facility. So it can get expensive. So it's always best if you can be proactive. So in looking at these things. Number 6, I'm a tenant, so I don't have to worry about exterior items. In California, actually in the ADA and in California, both the tenant and building owner are jointly responsible for interior and exterior barriers. Typically in a lawsuit, they would be sued together, and then would have to work out separately between the two of them who's going to pay for what. So, and more attorneys, yeah. So, number 7, I've already been sued, so I'm clear. Not the case. There's more than one potential plaintiff out there. And as we see, most lawsuits settle with a specific, either fixing certain things or fixing things to a certain degree, but it is no guarantee that somebody else might come along and find something different, another barrier, and can also sue. Or if there's a settlement agreement and there's the fix is settled on less than the full standard, then that leaves it open to another plaintiff. So I've worked with multiple business owners who have been sued more than once. So there's never been a disabled person in my store. And well, that may be true. It could be true that because your store is not accessible. when a plaintiff files a lawsuit, they don't actually have to have been in your store. They just have to prove, and that's a pretty loose term, that they were deterred from entering your store by the barriers. So that's not a good one. Number 9, I'll just help a disabled person get around barriers, and while that's great and can be helpful, and a lot of times lawsuits result because people feel that they have not been treated fairly, or they've been they've been told they can't come in, or they can't be served. So that definitely helps. But the goal of access laws is to provide for independent use of our community and built environment. So that's what they're geared to accomplish. So this is helpful, but it's not a fix. The last one, there's nothing I can do to reduce my risk. And that's definitely not true. You can reduce your risk. And so we're going to be talking about, hopefully, give you some ideas about how you can do that tonight. My partner in this business is an attorney, and so he told me I have to include this slide, so the disclaimer slide. So this is really just for informational purposes. Hopefully that will be the case, but it's not legal advice or architectural advice, or it's not a solicitation for services, and all those good things. So my partner will be happy with that. So just a little bit about myself. I'm an architect. I was licensed in 1989. I've been practicing in California since then, and mainly in Sonoma County, Santa Rosa, but I've been licensed in several other states and have done work in many states. Been doing accessibility work for about 20 years now. Really have focused that as the primary focus of my business for the last 15 or so years, and have started Pacific Access Consulting about 2 years ago with my partner Anthony Goldsmith, who is an attorney. We kind of bring together a multidisciplinary approach. So as an architect, I think of access as problem solving. How do I integrate all these ideas and this into the built environment? How do I help create a better built environment for everyone? My partner, of course, approaches it from the legal side. He has understanding the laws. We work a lot in Sacramento to help influence some of the laws, and one that we'll be talking about later. My partner spent a lot of time working on in the last couple of years that hopefully will help some small businesses. It is something I feel very strongly about. As an architect, I like to approach it from the business side, and try and help people become compliant and be compliant in their construction and alterations, so to avoid lawsuits. It's not fun to have to spend more money tearing things out or doing things twice, not doing things right the first time. So my business is primarily focused on working with owners, builders, architects, construction managers in ensuring that their plans and buildings and construction is accessible, so that at the end of a project it's fully accessible and compliant and there are no issues. So rather than coming back and having to tear things out and start over again, get it right the first time, that's always better. I've done a lot of litigation work, both plaintiff and defense, both Title II for local and state governmental entities, and for Title III for businesses such as yours. So I've testified in state court and federal court. I've been a court appointed to monitor settlement agreements for large Title II entities to ensure that over a multi-year period that they bring their facilities into compliance. Do a lot of mediation work to help mediate between plaintiffs and defendants to reach agreements before trial. So have a lot of that experience, and so I will probably be talking about risk management issues as we go through, because that's, as business owners, that's a big part of the consideration about what you do to become compliant over time. What's my risk versus my cost benefit? I wanted to just give an overview of what accessibility is, where the requirements come from, and what the triggers are. There's more than one. And if there's any questions as we go through, I'm okay if you want to feel free to ask questions. Accessibility is both a federal and state civil rights legislation, essentially is what it is. Federal is the Americans with Disabilities Act, is the one we all hear about and know about. There are many, both laws and regulations. The HUD has their own regulations for accessible housing. Department of Justice and federal agency that oversees healthcare have developed regulations for healthcare offices and hospitals. FAA has their own regulations for airports and all. So there's a lot of different access regulations depending on what your business is. That may come into play. So not just the Americans with Disabilities Act, but others as well. So depending on what your business is, there may be multiple different laws and regulations that need to be considered. In California has basically adopted several laws affecting access that go along or enhance the federal regulations. The first one was the Unruh Civil Rights Act, which is broad civil rights legislation and includes accessibility as a civil right in California. And more recently, there's a California Disabled Persons Act, which also addresses accessibility in California and provides for damages for plaintiffs in lawsuits. So typically in a lawsuit in California, it will include the ADA and either the Unruh Civil Rights Act or California Disabled Persons Act. Typically, the complaint will include both. They'll cite reasons for both, but in California, you have to choose one for the final basis of the lawsuit. They're a little bit different, and there are more legal reasons why an attorney might choose one over the other. But the reason we have so many lawsuits in California for access is because state law includes damages. Under federal law, a plaintiff can only sue for injunctive relief, removal of the barriers, make you do something, their attorney's fees. So California also allows a plaintiff to sue for damages. And damages are typically $4,000 per item. When this first came out in California, it also included $4,000 per item per occurrence. Subsequent legislation has said no, it's per item one time. So I heard stories when this first started happening, where a guy would he'd go to the same bar every day for lunch, and it was because it was not accessible. So every day he went there for lunch and got turned away. That was another item, another occurrence. Maybe there's 4 or 5 items that he's identified, and then every day for lunch, that's a separate occurrence. 4,000 times 5 times 5 days a week, it can add up pretty quick. There's also California Building Code, the other umbrella or trigger for access compliance.
I have a question.
Yeah.
So if plaintiffs can sue for damages and people are in business trying to do their best, what's the point of the damages? I'm understanding that, for instance, a grab bar or something can be a half-inch out of compliance, and I guess that's a $4,000 item or something. Doesn't this mean that it's virtually impossible for somebody to be in business unless they start brand new from scratch with the building, and they start out with somebody like you, and they do everything right down the line? Shouldn't we all just tear our businesses down and start from scratch? Because is there, and in addition to that, I want to ask, is there a comprehensive list somewhere of all of these rules so that we know where to go, or do we just have to be a personal attorney and know everything about the law for disabled people?
The first question is, I guess the way I'd start the answer to the first question is, shouldn't we just start over and from scratch? the intent of the ADA is not to put people out of business. It does happen. I've heard those stories. I know people who have decided to go out of business rather than to make fixes. But that's not the intent, and there are mechanisms in the law and that you can use to help that, to do your repairs over time, to do your fixes over time, to help pay for those repairs with tax credits and tax deductions, which I'll talk about here. And so we'll talk more about what do you do as we go through. So we will talk more about that. If there's more specific questions, ask me and we'll address them then. But yes, there are ways. And the second, excuse me.
The comprehensive list.
Yeah, so that's a hard one because there are lists. The California Building Code lays it all out, and the ADA lays
In
it all out.
plain language so that we can understand it.
The other place where it comes together, the CalDAG, is another reference material. It's easier to understand and get a handle on. In my opinion, it's the best reference book out there for professionals and for you. But it's not perfect. I didn't have a litigation practice because of where we disagree, where we have different interpretations. I mean, and so like probably 99.5% of what's in there I agree with. It's that 0.5%, other 0.5% that gets really kind of technical and subjective rather than objective, and where things are not fully laid out in guidelines or code. The technical requirements for the ADA are in the Americans with Disabilities Act accessibility guidelines. Why do they use the word guidelines? Why don't they use the word code or requirements? Because they aren't. That's not exactly what it is. They are guidelines. There is some interpretation. There is some application to specific conditions which need to be done. Often. Well, you can get a really good idea of the accessibility of your facility. It may not be 100%, and so I mean that's kind of why I'm in business, because of that part that is not fully laid out. For instance, the ADA, the overarching umbrella for access requirements states that facilities must be accessible to and usable by persons with disabilities. Very broad statement. What does that mean? It's laid out in the ADA guidelines, the ADAG, and in California Building Code, but those are finite. It's not a comprehensive list of every possible access issue that might come up. That's why we have new code that comes out. In 2010, we had several things added, several things newly scoped in the ADA and then the California Building Code that weren't previously defined or given guidance to. What does access mean for these elements? Recreational facilities, pools, golf courses, play equipment, miniature golf courses, camping facilities. All those items were newly scoped back in 2010. It didn't mean that we weren't obligated to make them accessible. We just didn't have specific guidelines on what that meant. So it was up to facility owners, business owners, their professionals that they work with to make the best guess about what accessibility meant for those types of facilities, applying the guidelines and code that we have in other sections. I recommend that you work with a professional who has a real deep and broad understanding of what these issues are.
This is the reason that we pulled this all together. This is extremely complex stuff. And the reason I brought Gary into this is because, honestly, I study this stuff all the time, and I still don't feel confident that I've got the whole thing down. And every time I look into one of these reference books, I find a new consideration. This is a small town. We've got a pretty limited amount going on. I don't see high-rise buildings. I don't see the kind of commercial stuff that they see in, for example, San Francisco. And I thought it best to bring somebody in who spent all of their time on this, because I can't. And even as much as I try, I got to admit, this is pretty tough stuff to get all the way around. So hopefully that helps, Bill.
We can make it easier, and that's the point. It can be easier for you.
You know, I've got a question and kind of a concern here. I don't think there's anybody that has more concern about disabled people than myself, because one of my very closest friends is paraplegic, and it was from a very tragic accident many, many years ago. But the concern I have, and I think everybody here is trying to comply, but your statements, and I'm not putting you in a spot, but it's the guesstimates and the codes. But really, nobody really knows until something happens and it's brought up. And I kind of think that we're in a blindside situation. If you know what the rules are and they haven't changed and everybody's trying to comply, John does his best job with the building inspector, and everybody's trying to get by with this thing, and then all of a sudden, out of the blue, we've got a change that nobody knew about, and all of a sudden somebody's in a lawsuit. Now, I don't think that's fair. I don't think it's fair to the disabled person. I don't think it's fair to the business people. And I'm hoping that you can explain a little bit better, but it just really rubbed me the wrong way. As I say, I have no problem with the Disabled Act.
But we're going to talk as we go through here about
Maybe I might
a
have
proactive approach and what you can do. But to address your concern about it seems to change all the time.
It does.
Okay. So how do you comply?
Well, just stepping back from that just a little bit, just to give you the broader picture, a lawsuit is going to be triggered by under the Americans with Disabilities Act. In California, there's a part in Civil Code, I think in the UNRU Act, that says a violation of the ADA is also a violation of California state law. So California lawsuits get triggered because there's an ADA violation. The guidelines for the ADA came out in 1992 in the ADA. And for the most part, they haven't changed. I mean, those guidelines were updated in 1994 and 2004. And that's still the same guideline that becomes the basis of our 2010 ADA. There have been some things added to that to expand the scoping because we realized that there were some things missing, as we just talked about. But they were your professionals that you work with, if you did a construction project, should have thought about that as well. But those guidelines haven't really changed. They do get interpreted because of the way Congress set up the ADA originally. They set it up so that it would be enforced through private litigation. 90% of enforcement is through private litigation, for good or bad, for political reasons. I mean, this is a Republican law. It was passed under the first President Bush, and I think the sentiment at that time was, let's not set up a bureaucracy to enforce this, let's let the public enforce this. And so that's, while the Justice Department does bring some large-scale cases against, you may have heard that there was a case a few years ago against Hilton Hotels that involved 800 sites. Many, I think Humboldt County just entered into a settlement agreement with the Department of Justice for their stuff. Most of the Department of Justice work is dealt with large corporations or public entities, Title II, state and local governments. Most of the enforcement through Title III or the business sector is through private litigation, which means it goes to court, which means the arbiter of how to interpret the ADA requirements is taken out of John's hands for the most part, in a lot of cases, and put into a judge's hands who has no background in what this means in the built environment, or into lawyers who make settlement agreements. And then, so there are interpretations that happen out there. Part of my job is to stay on top of that. What are the latest interpretations? How have things changed through court and through litigation, through settlement? And so things get defined that way, but the requirements themselves haven't changed.
How does an owner of a building or a business stay up on that? I mean, how are we supposed to know all of this stuff?
That's really difficult to know on your own. I'm a business owner. I've been in business for 20 years.
So
I can't
my
know
point
everything I
being,
need to know.
then, if you are not doing new construction and you're going to the very best to do your new construction and to bring it up to speed, that's one thing, and I appreciate that. But if I got an existing building or a business person, how are they supposed to know what's required until they're sued?
My recommendation, my best advice, hire a CASP, a Certified Access Specialist, to assess your building and your business, because it's both your building and your business, and to give you a report and create a proactive approach to becoming accessible, and we'll talk more about what that means. But then also, if you, I mean, I call my accountant every year and say, is there anything I should know before I do my taxes? I'm in November. What should I be thinking about in planning for year end? If you have an access specialist, hey, did anything change that I should be aware of? Anything, that you know my business, you did the report. Is there anything I should be thinking about? It should be an annual look at that report. Because you probably are working on things over time. Two, just to make sure that things haven't changed in the way your business operates that are going to affect accessibility. And then, so put it on your calendar for one day, a year. Pull out the report, take a look at it, call your access consultant. That's the best way to try and stay ahead of things. That's what I do for my clients.
So if we hire a CASP and have them come out and inspect our business and our property, and they come up with a list of things we need to work on, what is the timeline for us to actually complete those things?
Yeah, so that's a good question. And we will talk about that when we get through readily achievable barrier removal. So when I say those words, that's what we're going to talk about. And there is not a specific timeline that's laid out in law. It's looked at on a case-by-case basis. So it gives you the opportunity to make the case for yourself as to what your appropriate timeline is for your business and your resources.
But if you've had that CASP done, then are you somehow protected from a lawsuit?
Potentially. Not necessarily, but it gives you a defensible position, which is, and if you have it done before you have a lawsuit, there are protections in California law that you get if you have it done before you have a lawsuit. The reality is that most lawsuits are filed in federal court under both federal law and California law, and we'll talk a little bit more about that too as to why. Federal court has a little different look at that. They don't necessarily have to follow California law. But there are places, provisions in federal court in the district that we're in that provides a streamlined process to reduce court costs and that kind of thing if you are in a lawsuit. But also, if you've got a report in place and you're proactively following it, you're a lot farther along, and you have a real strong defensible position. It's when we bury our heads, we don't address it, we don't look at it proactively, we get ourselves into trouble. Even though sometimes it feels like, if I don't know, it can't bite me, but it can. So.
And I just wanted to add, part of the reason why we're doing this is so that we can figure out, as a community, as a city, as a chamber working together, to stay on top of this. And so while each of you have your own businesses that have different potential issues, in terms of annual updates, that's something that the chamber and the city can partner on and getting that information out to everyone.
We could always look at something like, what's a summary of changes for this year that our business community should be aware of? Put something out through the chamber or through...
That address the typical small business owner.
I mean, I probably have, this building code came out January 1st.
5 of those. So
5 addendums already since it's come out. Some of these do affect accessibility. I don't even have this one put into my book yet. So, So things do change. We could look at providing information that could go out on a one-page flyer or be posted at the Chamber of Commerce website as to, okay, a new something just came out on accessibility.
A way to think about this, with the guys that write the regulations, they're always trying to get it right also. They can't say, okay, we're done for 3 years, we're not going to look at anything until 3 years when the new codes come out. But that doesn't actually work, and the courts won't support that. The courts are going to say, if you have the information available right now, we need to act on it right.
Do all of your exits and entrances need to be ADA compliant?
In new construction, all ground level entrances must be accessible, and there are requirements for that. I mean, so even if it's only an exit door, it must be an accessible exit and as part of the exit way that stops at either the public way, the city sidewalk, or 50 feet, from the building somehow, an accessible route of travel that gets to a safe area away from your building or to the public right of way, the city sidewalk. And so not only that exit door, which is what most people think about when they're talking about exits, but it's the exit way, the exit path from the farthest point in the building that's served by that door all the way to the public way or 50 feet from your building to a safe area. For new construction.
New construction.
For new construction. For alterations do not, for existing buildings that met the building code at the time they were constructed or were built before the ADA, accessible exits are not triggered by alterations to existing buildings. Because that can be very difficult. A lot of times we have stairs or we have, we just don't have a way to make that accessible. You may need to come up with another plan, well, how do I accommodate somebody? Do I need a policy for staff assistance or that kind of thing? But an alteration is not going to trigger that, compliance for exiting, as long as it was built in compliance with the building code at the time. So the other thing is exiting, like several things in the building code, only have accessibility requirements where they're provided or required by other parts of the building code. Exiting is not a specific access issue, but because we have exits, the chapter 10 of the building code, which talks about exiting, also talks about accessible exiting requirements. So for the most part, access requirements are contained in one specific chapter in the building code. There are requirements in other parts of the building code. That happens to be one of them. On the ADA, there are 5 titles. The 3 main titles we're going to hear about, you probably need to be aware of. Title 1 deals with employment issues. For businesses, you have to think about Title 1 if you have employees. Basically, it means if an employee has a disability, you need to accommodate them in their job so that they can do their job. That doesn't mean that everything in your facility has to be accessible or you have to fix it in compliance with the code, but you need to make accommodations so they can perform their job. That may be a negotiation between you and your employee. Title 2, state and local government. That's the city of Willits. I'm working with Mendocino Lake Community College. We have a satellite campus here. I was up there looking at that a few weeks ago. So state and local governments. Title 2, different requirements than you have. State and local government has to make sure that their programs are accessible to the disabled. Not that all their facilities are fully 100% compliant, but that their programs are compliant. So any facility that was built prior to the ADA, that's the standard. After the enactment of the ADA, then their buildings, facilities need to be built so that they're accessible. But anything that was here before then, we just need to make sure that the programs are accessible. Now, you guys have a different standard than that. Sometimes it's more strenuous, sometimes it's less strenuous, but it's a difference.
Could you define program? What do you mean by that?
Basically, anything that the governmental entity, city or county or school district, any services or anything that they do for the public is a program. For instance, one of the most recent cases, and that is pretty a hot topic or a hot issue in access now, is sidewalks. City of, or Barton versus the city and county of Sacramento, back several years ago. My partner was a consultant on that case. For the city, which lost eventually. But it's basically the argument from the plaintiff was that sidewalks are a program offered by the city, so therefore sidewalks must be accessible. And what does that mean? But City Hall, police, fire, community centers, public parks, if there's a swim center, sidewalks, curb cuts, public parking. Those are all programs that are offered by the city.
Thank you.
Title III, basically it's under the ADA, it's going to affect new construction and alterations. New construction and alterations have to be fully compliant with the ADA and California Building Code. But for the ADA, that's the ADA and the 2010 ADA standards. And then readily achievable barrier removal. That is separate from a building project. It's an ongoing obligation, and we'll talk about that coming up a little more. Under the California Building Code, we have obligations only for new construction and alteration. The readily achievable barrier removal is a federal ADA requirement. So under the building code, you're only going to get triggered when you submit for a building permit. If you don't submit for a building permit, the building department is not going to tell you or talk to you or have any responsibility or obligation or business talking to you about access. They legally can't enforce the ADA. I do a lot of work for the Division of State Architect for 15 years, doing as an outside plan reviewer for school projects. And it became very frustrating because although the ADA and the California Building Code are significantly more aligned now than they used to be, there used to be some really significant differences between the two, and we were not allowed to enforce the ADA. When approving school projects, only the building code. So we could say, by the way, this isn't compliant with the ADA, and yeah, so? But, permits trigger access requirements under the building code. So the ADA and the CBC do have similar technical requirements. As I said, they are much more aligned now than they used to be. There's one main item in the ADA which California missed in the most recent code, which makes the ADA more restrictive, and that catches a lot of us, and that has to do with path of travel through a facility. And if you own a restaurant, and it's going to have to do with your accessible tables and providing a path of travel through. So if you own a restaurant, talk to me about that. I can tell you about that. For alterations, the area of alteration must fully comply. If I'm remodeling this room must be fully in compliance with all the requirements for the elements that are in this room. Also, the path of travel leading to this room must be addressed as part of the project. The path of travel is going to include how do I get here from the sidewalk, across the property and into the entry door, from the entry door to this room, to this space, and how do I get to the drinking fountain, public telephones, and restrooms that serve this space. So those are all part of the path of travel obligation that needs to be looked at. Under the ADA, you're limited to 20%. You only have to spend an additional 20% of your budget to address those types of issues, no matter what the cost is. So if my alteration costs $100,000, then I need to apply a maximum of $20,000 to address barriers in the path of travel. Under California Building Code, it's a little bit different. It's a little more stringent. There's you'll hear it referred to as the ENR, Engineering News and Record threshold. And above that number, which I think for this year is $156,000 or $157,000 of construction cost, above that number, there is no cap on how much you have to spend, with one exception, and that is you can apply for a hardship to John, and there's probably a form or format to do that. And if not, there is one in the CASI website, CASI's my professional organization. And you can request a hardship, and the local building official can grant that hardship. Under the threshold, There's a 20% cap on the amount that you can spend, just like the ADA that you have to spend. So if your project costs $100,000 and you have $50,000 worth of access work to do in the path of travel, you only have to spend $20,000. Now you may have to negotiate with John about where you're going to put that $20,000 and what makes the most sense for both you and for the building code priorities. If I'm working with you, I'm going to try and work with you to analyze your business and what makes the most sense for you, your business and your customers to best serve you and your customers in spending that $20,000. And then we would negotiate with John or the building official to get that concurrence. But if you have a $200,000 cost for your alteration project, then and you have $200,000 worth of access improvements to make, you're going to have to spend that full $200,000 unless you get a hardship. With that extreme example, you probably will, but it's more of a process.
So with the 20%, say you got a project and you spend the 20%, so you don't ever have to fix the rest of the stuff?
No, no. You still have things that you haven't done, and that's where we get into the readily achievable barrier removal. There may be certain things in that, so you're going to have a list. You've knocked off this much of the list as part of your alteration project. You have this much of the list left. Maybe this much is something you would have to do. Maybe this much is not readily achievable. So under the ADA, you can make an argument as part of your task report that you can't do this piece of work because it's not readily achievable. Now, if you do another alteration project, which would include that may trigger that you have to do that work that's not readily achievable under the ADA. You may have to do it under another building project, but you could build yourself a defense as why you don't have to do it under the ADA.
So then if the attorney that's suing you isn't that quick, you probably win that.
You could. It depends on how much you want to fight. Now, so what happens, unfortunately, the reality of what happens in a lawsuit like that is that the plaintiff attorney is going to want to see the support for your determination. They're not just going to accept your word that it's not readily achievable, I can't do that. They're going to want to know see the backup and justification for that, which means financial records for the most part. The big deterrent for most business owners is that means they get to look at your financial records and tax returns to find out how much money you made and how much you have allocated toward barrier removal and if that's fair or not. And for a lot of business owners, that's a no-go. They don't want to disclose those records, and so they figure out other ways to negotiate settlement or whatever. But theoretically,
There's no get out of jail free card.
But potentially there is, but it may not be something you want to do. That's part of your risk assessment and thing that you need to make. So readily achievable barrier removal means, essentially it means easily accomplishable without much difficulty or expense. There's 5 criteria for testing that. Essentially the 5 are the nature and cost of the improvements needed. Do I have to put it in, if I have a 2-story building, do I have to put it in an elevator?
Yeah.
No, that's not readily achievable. It never is going to be readily achievable, and that's really been determined by court action. So in this case, court opinion is serving a lot of business owners because they're not going to have to put it in an elevator. But the next one is overall financial resources of the site or sites involved. That's your financial records, how much income do you have, how much is set aside. There is no specific amount that you have to set aside. There's a lot of discussion and talk about that in writing the ADA. There's a lot of push from the disabled community to put a percentage in there, and they wanted a high one. There's a lot of pushback on that. Ultimately, there is no percentage or no guideline for that. A good guideline would be 1 to 2% of your income from your business set aside to make each year, to make improvements to remove barriers. Just as a quick example, let's say I've got a bathroom that's not accessible. If my bathroom's too small, I've got to enlarge my footprint. I've looked at what that means. I've gotten some cost estimates. I had my contractor in, and they said it's gonna cost $25,000 to make that improvement. I make $100,000 a year on my business. I can't do that. That's unreasonable. I think most courts would going to agree with that. So I've determined that I can set aside $1,000 a year to make those improvements. So each year I'm going to so right now making that restroom accessible is not readily achievable. But in 25 years it may be. Or if my business next year, I make $200,000. Well, I'm going to then relook at that and set aside a little bit more. So that is the process that you have to go through, and that's why I say look at it on an annual basis when you pull out, at least once a year. Look at how much, if you're setting aside money for readily achievable barrier removal, make that adjustment if you increase, your revenue, if you decrease, if there's a downturn in the business economy, like a 101 bypass opening. Well, I can't afford the same amount I could last year to make these changes, so I'm going to legitimately reduce the amount that I'm putting aside for readily achievable barrier removal.
What about a nonprofit organization?
They are
That
also
runs on
covered.
grants and everything?
Right now, I'm working with Canine Companions for Independence, making their facilities and the nonprofit. And they serve. It's a business that serves the public. It may be a nonprofit business, but it's still a business that serves the public.
So what I hear you saying is, get a plan in place, have someone like yourself come out, start working towards achieving a goal, and that pretty much covers you.
That is the best thing that you can do
Okay.
to give you the best defensible position, is to have a plan in place.
Well,
You may need to tweak
we
that
want to be
plan.
compliant, for
Yeah.
everyone. Another question I had is, in your experience, I'm sure you have a couple of reasons why people are sued. Some just want access. They just want the situation resolved so they can have access. Then I think you're going to have some people who are just out looking for money to get paid, because California's the state to get paid.
California's the
That's
state to
the
get paid.
concern that I have. Through mediation, can they pull this out and drag it out as long as they want and say, how would that work?
Well, those type of lawsuits are gonna get, those types of lawsuits, if they don't settle because you offer money, 90% of those are gonna, hey, you asked for 50,000, I'll give you 10, will you go away?
Yeah.
Most of the time, they're gonna go away because they're looking for a quick payout. For those who don't, at least in this jurisdiction, this court jurisdiction, there's a mandatory mediation. So you cannot go to court prior to going to mediation. It's mandatory. Yeah, and it is. I do a lot of mediation. I was in one a couple of days ago. The mediator who led that one heads the mediation process for this court district, and he said 95% of his mediations settled. This was a pretty contentious lawsuit. It settled. I mean, my part was, I was there for the injunctive relief. It took us 6 hours to get through the injunctive relief and get agreement on the 60 items that were in the report, barriers, as to what was going to be fixed and what wasn't. What happens is you get a plaintiff that's going to hire an expert to go out and survey your property and come up with a list of everything, whether it's a 1/4 inch off or 1/2 inch off, whatever they can measure, or if it's non-existent, it's going to be on the list. A lot of those things are throwaways. They're there for negotiation purposes.
Okay.
And the attorney is going to then go, okay, these are my 10 items I can throw away in exchange for these items. And then the rest of them, some will settle with something in the middle. But that's how that process works. But it's a much cheaper process than going to court. But if you can avoid that altogether, the best thing to do is avoid that altogether. Get a plan in place. Make it difficult for those people who are looking for a fast dollar. A plan is your best insurance policy. Say there's an accident, it's a PI case, personal injury case. A lot of times they'll try and tie those personal injury case to an access issue, because I can get treble damages for access issues. But if the impetus for the lawsuit is a personal injury case, then the insurance is most likely going to cover that whole case. But strictly a access barrier case, you're not going to find insurance coverage for that. So readily achievable barrier removal, this comes down to your risk and risk tolerance versus financial resources. That's really what this is. As we talked earlier, there is that mechanism for determining that something's not readily achievable, mainly based on financial costs, financial reasons. There are certain things that are just not going to be required, like putting in an elevator, putting in a lift. There is the ADA and California Building Code lists several things that are considered to be readily achievable. Putting in a ramp to an entry door is considered to be a readily achievable type of barrier removal, and as an example given specifically in the code. Well, sometimes there's not room to put a ramp. Now I'm thinking of a specific case that I'm involved in. There's not room to put a ramp because of the location on the property and to the sidewalk and setbacks and other issues. But if you could, the cost of the ramp would have been about $25,000, and it would have been considered readily achievable. And the judge, in this case, this one did go to court, would have required that if it was technically feasible to do, but it wasn't. The plaintiff attorney suggested a lift, which would be a little less than that, less expensive than the ramp. But the judge equated that to an elevator and said, no, that's not readily achievable, even though it was probably a less expensive solution. So they didn't have to do anything. The defendant won that lawsuit. Now, that may not be the case in the next lawsuit that comes up, because, again, that was a judge's decision, and that's, under the ADA, that's where it ends up. Sometimes the court will issue an opinion, written opinion, which then can be used as precedent in another case. But unless there's a written opinion issued, it's going to be on a case-by-case basis.
How often do people go out of business because between the attorney's fees and the judgments to make the repairs, how often does that happen?
I don't know. I don't have a statistic. I do know that
It seems like
there
in
are
a small
businesses
town
that
with
have.
mom and pop businesses,
Really the thing that you have to do is to take advantage of the readily achievable barrier removal and spread things out over time. How am I going to identify a target if I'm a drive-by litigant? I'm going to kind of cruise around town and look around. First thing I'm going to do is I'm going to look for your parking, because if I'm driving around, that's the first thing I'm going to do if I pull into a site. So, I pulled into a site and I don't have accessible parking or compliant parking. The first trigger that I'm going to see is, do I have signage? Do I have my parking striped in compliance? Now, signage and striping are pretty low-cost items to make sure you're compliant. Going back and addressing slope, maybe my parking space slopes at 3% instead of 2%, and it's going to take an asphalt overlay to make that compliant. Well, yeah, I could do that now, but it's going to be more expensive, and maybe I don't have the funds to do that now. But if I'm a drive-by guy looking for a lawsuit, I'm not going to be able to really, most likely, tell that it's sloping at 3% instead of 2%. And wait a minute, the signs are there, the striping is there, that all looks good. Maybe I'll look someplace else. So taking care of those low cost, the low-hanging fruit for the items that you can take care of. And at the end here, we've got a list of the top 10 most common barriers that trigger lawsuits. And so looking at those and seeing what you can do inexpensively, getting rid of those things that people are going to see first as they progress through your property, that's the biggest thing. If you're in a part of town where the parking ordinance allows for on-street parking and does not require the business to provide its own on-site parking, then parking is a program of the city. Literally, yeah. Some things the city is going to require, may be able to require you to take care of. For instance, if you have sidewalk, a lot of times as part of a use permit or conditions of approval, the city may require you to maintain the sidewalk. And so you may be obligated to do that. But unless there's a condition in your conditions of approval for your building or use permit that addresses parking, and you're in a parking district, then that's a city program.
These drive-bys, you know, the ones that have an attorney and they go around and, you know, is there any kind of I mean, does the court say, hey, you know what, you've done this 10 times in the last month?
Well, there is a very strong push for that. There have been some of those plaintiffs that have been sanctioned. So what happens, the guy who decides, well, I'm really hungry, I'm gonna go hit 10 fast food restaurants today, and the complaint lists the same 5 items for all 10 locations, but half of them, you know, don't have multi-accommodation men's restrooms or women's restrooms. They have single accommodation. So they obviously are just using a boilerplate. And there have been at least a couple of plaintiffs that I know that have been sanctioned for using boilerplate and just doing that because they haven't been really diligent about getting the facts straight. Now, there's also some legislation that was up last year in Sacramento that would have labeled a plaintiff and or their attorney as a, I forget the term that they use, but basically it says, you sue too much. And so we're going to say, we're going to limit the number of lawsuits you can file without meeting certain criteria. So we're going to allow you to file 10 ADA lawsuits either as a plaintiff or as an attorney. This drew a lot of fire from the Bar Association because that, you know, after 10 you have to show us you have to prove certain things before you can file another one. So that I don't believe that passed, but there's another version that there's some other things that passed last year that do help small business. But that, I bet that something like that will pass at some point.
It would seem to me more prudent that if a handicapped person has a problem and designates that problem, that it would go to a person that would say, hey, let's go and look at this, rather than to a lawsuit that costs everybody a lot of money. And the bottom line is the only people that seem to be making money on this are the attorneys. And that kind of rubs everybody the wrong way.
It does.
Because I don't think anybody in this audience is here to jeopardize their position or the position of any handicapped person. So there needs to be some sort of an avenue that says, hey, you know, you got a problem, we're going to come and say you need to fix it. Hire a person like yourself and give you 6 months, whether you have to finance it or not, to take care of this. Rather than to go hire an attorney that's going to immediately file a lawsuit that triggers you getting an attorney. And what I liked for you when you were saying that you could put this money aside and set it aside for down the road, and like Rick says here, that your building costs go up, so that money that you're setting aside now doesn't mean diddly squat 25 years. And you're also paying an attorney to maintain that while you're going through this. So, I mean, it becomes a no-win situation. And I think really the California law needs to take a look at what they've done to businesses in the state of California. I don't think it's just in the state of California. Again, I'm not anti the handicapped people, but what I'm saying is realistic is what we need to have. And this is not realistic. I'm not arguing with you. I'm saying that it's wrong what's happening. And I think that legislator needs to take a look at this and say, hey, let's stop this. Let's stop this madness and let's see how we can help these people and help the property owners and the business people.
There is a real push in Sacramento to figure out ways to limit lawsuits. There really is. It's gaining momentum. And over the last few years, there are probably, I don't know, I've probably seen the number of proposed legislation probably double and triple over the last few years. And it's probably going to continue that way until, you know, at least for now. And there may be, you know, it could be a drastic change in the future. but there are some steps. One that was the most effective law that was passed last year is SB 269, which was passed in May, I believe, May 10th, I believe it became effective. Became effective immediately when it was signed by the governor, and it provides some mechanisms for small business to minimize the drive-by lawsuit and provide some protection and time frame to address the issues. So just jumping ahead in here, this is probably the biggest thing you can do is to take advantage of this. You have to get a CAS report. The state set up the CAS program in 2008 to provide some level of, and the first and one of the only in the country, other than I think that Texas has a certification, but California Certified Access Specialist is the licensing, insurance that somebody does have at least a minimum level of proficiency. And there are, 500 or 600 CASPs now in California. Started in 2008. I'm number 65. I took the second exam that was given. So there aren't a lot of us, but there are more and more now. Now, so you have to get a CASP report. There are a lot of CASPs out there who, even though they've passed the test, and it's not an easy test to pass, I think the pass rate is about 30% or less. There are a lot that really don't do a very good job. So I would hire a CASP who is a member of our professional organization, CASI, Certified Access Specialist Institute, and we have, some professional qualifications, some professional requirements we have to maintain. So I think that you get a higher proficiency of report that way. Yeah.
Just out of curiosity, what does a CAS report cost on the average?
It's going to cost anywhere from, for a small business, anywhere from probably $800 to $2,400 for a small business, depending on like for when I come into a town like this.
Clarify small.
5,000 square feet, a typical retail shop, a gas station, a convenience store, a typical storefront that you might have here. And for instance, if I'm coming in and like working with a chamber or group, and if we got a number of people, if I had 2 or 3 or 4 clients that I could come up and do surveys for, give a group discount essentially. And most CASPs will do that most likely. So it doesn't have to be me, but I would recommend a CASP who is a member of CASI. And if you can get, even if it's just amongst yourselves, if you can get a group or a number of people to come in and do it, negotiating better rate. I mean, I do that. Yeah.
If you get the inspection, does that give you a certain level of protection before you even address any of the issues that are brought up?
It can. The CASP program was established. It was established SB 1608 in 2008. Construction-related accessibility law, and it basically said that if you get a CASP report, you'll get certain protections from state court. You can get an immediate stay. If you have a CASP report, you have an immediate stay of litigation to give an opportunity to mediate, to go meet before a mediator and work out a settlement.
Costs on lawyer fees, right?
That reduces your costs on lawyer fees. It also provided for a reduction in damages from $2,000 per per item, from $4,000 per item to $2,000 per item. And under certain conditions, it could be $1,000 per item. It gets pretty technical in the legal as to what would constitute that or not.
So didn't you say that the majority of the cases that are filed are federal? Does that apply to a federal lawsuit?
So, in a federal lawsuit, well, let me step back. The California law includes both procedural and statutory elements. The procedural elements are the stay of litigation and the settlement conference. The statutory elements are the damages. Federal court does not have to follow California procedural elements or procedural requirements. They follow their own federal requirements. And each federal district will establish their own procedural approach to access cases. In San Francisco, like I say, they've adopted a mandatory mediation, which stays litigation until you go through this mediation process. Other districts have not adopted that, so it's going to depend district by district. But they do follow the statutory elements of California law for the reduction in damages. So if you have an access report, a CASP report, you can get the reduction in damages. And you can get it, so it's not per occurrence, but per item. So it's with a CASP report. With SB 269, you not only get the benefits of the reduction in damages, if you have a CASP report and the CASP report predates the lawsuit and or a demand letter, if you get a demand letter, you get a 120-day break on damages. If you fix the barriers, remove the barriers that are part of the access or the complaint, within 120 days of receiving the complaint, they don't get damages.
And you said this district is also mandatory mediation for sure?
Yes, in federal court.
Does this CASP report and the stuff you're talking about, does that determine whether they sue in federal court or state court?
No, it's usually going to depend on the attorney. The attorney can make that decision. And it usually depends for the attorney of where they feel most comfortable, where their most experience is. My experience is that most lawsuits, the ones I've dealt with, have been filed in federal court.
I guess the question I'm asking is, do you get the same advantages at the federal level as the state level if you have this?
For this, you do because, the reduction in damages, yes. I don't know that this has been tested in federal court yet, the 120-day limitation, because it's pretty brand new. But I've not dealt with a case that's had that as an issue. But that is, I mean, if they do sue in the state court, that would definitely be no damages if it's fixed. So look at what the complaint is, look at what's easy to fix and inexpensive to fix, and fix that within 120 days. Signage, lowering a mirror in a bathroom, replacing grab bars, in the parking lot, those things, anything that doesn't require a building permit, you're going to be able to do, and most of those are going to be fairly inexpensive. Now, if it requires a building permit, John, this law also says that a building department must provide an expedited permit process for barrier removal under this law, so that you can meet your 120-day process. And I don't know what that means for you, whether expedite, because it doesn't say it has to be done in this
I'll
amount
tell you
of
what
time.
it means for me.
But
It means I'll work with anybody that wants to remove barriers however they need.
the other thing that you should know about barrier removal, even if you need a permit, work done to remove access barriers does not trigger any other building code requirements. It can be, you can do a barrier removal only project. So for instance, I want to go into my bathroom and fix part of it, but I can't fix everything. And I wouldn't be required to fix everything if I'm doing a barrier removal only project. So you can select, even if it requires a building permit, you can select items from your barrier list, from your identified list, and fix those one at a time, or two or three at a time, with a permit, without triggering anything else.
Restroom accessibility.
I'd be happy to work with any of you on that.
Restroom accessibility in California, are you required to have a public restroom? Is there a difference between public restrooms and no public restrooms?
That is, the requirement for a restroom or not a restroom is not an access issue. That's going to depend on the plumbing code, or maybe if you're a restaurant, or the health department requirements. If you're a gas station next to a freeway, on Caltrans requirements, if you're a certain distance from a freeway, you don't have to have a restroom if you're a gas station. But most restaurants or food service are going to have a restroom for health code or plumbing code.
So what about your average shop in town that's not a restaurant? They have a bathroom and it's out of compliance, and they put up a sign that says no public restroom.
If you're not required to provide a restroom for the public, then you can do that.
Is there a
Then your
list?
issue would be an employment accommodation under Title I.
Is there a list that you can go to that describes and breaks out which businesses are required and which ones are not?
That's going to be jurisdiction by jurisdiction, so talk with this guy, or planning maybe, or health department.
But to be clear on this, the California Plumbing Code requires restrooms to be available to the public.
Handicap business?
Yeah, that's the California Plumbing Code, and that means if you submit a set of plans to me to build a new building, that's one of the requirements.
What about existing buildings?
Existing buildings, a whole different program. I
So-
have a lot of leeway as the authority having jurisdiction to place a lot of that judgment in my court.
So then does the bathroom accessibility have to be noticed? So if you have an older bathroom, or an older building that has a bathroom existing, and you put up a sign, do you have to put up a sign that says no public restroom?
Well,
If you try and make that restroom accessible, I'm gonna be a lot happier with it than when I see a sign that says no public restrooms. To me, that's just avoiding the problem.
But if, again, you may be able to tackle that on piecemeal basis as well. And I would certainly go in and do what you can that's easy to do. Like, I'll tell you, in a bathroom, let's go to one of the common triggers. The top, at the very top of the list of the most common ADA lawsuit triggers is restroom accessories. Restroom accessories include the toilet paper dispenser, the grab bar, the paper towel dispenser, a hand dryer, a baby changing station, a mirror, a soap dispenser, all those elements. Bathrooms are the number one, aside from parking, which is probably your first trigger, bathrooms are the number one area for lawsuits and complications or complexity for access compliance, because there's so many different elements in there and they have different requirements than other elements that are not in bathrooms. For instance, the reach ranges are more restrictive in bathrooms. The operating mechanisms can't be more than 40 inches above finished floor. In other locations, that same paper towel dispenser, the operating mechanism could be 48 inches above the floor. If you have a sink in a hand wash sink in a kitchen, the paper towel dispenser, the operating mechanism can be up to 48 inches above finished floor. In your bathroom, it can't be more than 40 inches. Making sure that all your accessories are positioned correctly is important, and oftentimes easy to do and not too expensive to do, and often get out of compliance easily, and so it's something to be aware of. I do a lot of work for companies that have multiple sites, and they have paper product vendors who come in and say, hey, as part of your, I'll provide all your paper products, and I just need to change out your dispensers to fit our stuff, and those are free. So they go in and they replace all your paper towel dispensers and soap dispensers, and they replace them in the wrong location, and then you're stuck with an access issue that is one of the top triggers for an ADA lawsuit. So make sure that when you do that, that it's compliant.
Where did they base the 40 inches from? From the bottom of the dispenser, the top of the
To the-
dispenser, or from where the paper comes out?
Could be at the highest operating point of the operating mechanism. So if I have a paper towel dispenser and I'm pulling it down on the handle, the top of the handle, and
The
it's
top of it's true.
yeah.
Well, it's that technical.
That's where it takes it from.
Because
Now,
you're looking at somebody from the lowest ground up being able to reach.
yes, a toilet paper dispenser, and these things. This is fun to talk about. This is where I live in my day-to-day world. I live in bathrooms and businesses because that's where most of the issues are. But a toilet paper dispenser, how many different kinds are there? There's a lot. Do you have a roll dispenser? Is it a stacked two-roll dispenser? Is it a side-by-side roll dispenser? Is it an enclosed dispenser that's oversized? If it's a roll dispenser, I'm going to measure to the center line of the roll. If it's a stacked roll dispenser, it has to be below the grab bar, and the bottom roll can't be less than 19 inches to the center line above the finished floor. If it's an enclosed toilet paper dispenser. I'm going to measure to the outflow of the sheet. And that's going to be 19 inches minimum to above finished floor. And the center line of that outflow is going to be 7 inches to 9 inches in front of the toilet. It depends on what it is, and if you have a seat cover dispenser, I'm going to measure to the top of the opening in the dispenser, not the bottom of it, because that can be placed anywhere.
At the senior center, we have a men's bathroom, we have a women's bathroom, and then we have a neutral bathroom for men or women. If we just take that neutral bathroom and make it completely ADA compliant, are we legally taken care of?
No.
Okay.
So when you are, until March 1st, the building code requires separate sex restrooms.
Okay.
Now, in some cases, like a lot of jurisdictions for existing buildings, particularly at small coffee shops or restaurants or whatever, where under a certain number of clients or occupancy, when some jurisdictions will allow one single accommodation restroom to serve both men and women, because it would be prohibitive to require the addition of a second restroom. I know a number of cases where I did a case in the city of Berkeley where we worked with the health department, and they established a policy that under a certain size or number of occupants or employees, I can't remember what the criteria was, they would allow an existing building and business to have a single for both sexes for employees and guests. That wouldn't work for new construction. But talking about single occupancy restrooms, so if you have both men's and women's multi-accommodation restrooms and you have a single occupancy restroom, not only do your multi-accommodation restrooms have to be accessible, at least 50% of your single accommodation restrooms have to be accessible. And if they're not, if you have more than one and they're not located together, then both of them have to be accessible. But when they're grouped together, then there can be a reduction in the number of accessible restrooms because of that. But that's, and now, and this is not an access issue, but it affects accessible restrooms. As of March 1st, single accommodation restrooms are going to be gender neutral, all of them. And so everybody has. I just talked with a major oil company yesterday about, they're implementing a program through California to replace all their signage at their stations throughout California by March 1st to the gender neutral signs for all their single accommodations. So,
what are the requirements for complying if the disability is blindness?
Okay, there are different disabilities. Not everybody's in a wheelchair. In fact, it's a small percentage of the disabled community that's in a wheelchair or wheelchair users. About 18 to 19% of the population is either disabled or will have a disability at some point. About 7 or 8%, I think, are wheelchair users. So a lot of them a lot of people are going to have other disabilities such as deafness or blindness, visual impairment. There are requirements in the building code and ADA that address both hearing and visual impairment. You see the truncated domes at curb cuts a lot, the yellow mats with bumps. That's for visual impairment. So in a lawsuit, the person with a disability who has a mobility disability cannot sue for visual impairment issues or
Vice versa.
stuff, and vice versa. So it depends on what they have to be specifically affected by the barrier in using the facility. And somebody with mobility disability is not going to be discouraged or unable to use it because of the truncated domes of the mobility. If you're a hotel owner or a hotel or motel owner, you are going to have both mobility access requirements and communications or hearing impaired requirements for access. Two separate headings in the building code with different requirements and different numbers of rooms that are going to be accessible. So there's definitely provisions for different disabilities, the wheelchair community has the strongest voice in California. And so, as with many things, access code is a political process. And it's vetted through the public. Public has public comment, and there are competing interests of the disability community for what the requirements are going to be.
Is there a place you can go to get the height of all, like the mirrors? Is there a website or somewhere where you can do that?
Well, I would, for a quick reference, and I'm not sure where it is in the new one, but there's a section in the CalDAG that addresses restroom accessories, and it has a list of 10 or 12 the different accessories and types and what the requirements are for them. So if you're interested in restroom accessories, you can go to that page, and the requirements are going to be there on that one page.
Because they probably changed as of 20 years ago, or no? Or it'd be just a good thing to check every year.
I found it online also. Yeah, you can probably, I'm sure you can find it online.
You can get it online?
Let's see.
The entire California Building Code is available online.
Okay.
Go to the index and find what you're looking for, and all that would be in one spot on one page.
Honestly, if you don't have access to the internet or something like that, and you'd like to give me a call and come in, take a look at my book, that's fine with me.
All right, thank you.
Yeah, it's much easier to find it in that book than it is in the building code, because you may have to go to multiple places in the building code to find it. You won't find the heights for accessories necessarily in the restroom section. There may be other sections to look at. And in the ADA, you won't find any reference to it because it's governed by the general provisions for reach range. So that book becomes handy because you can go to what you're looking for to find the information.
I have a question in regards to guide dogs.
Yeah.
Is there like certain requirements, or can we ask, do you have a certificate, or because there's sometimes customers, I'm sure it's legitimate, other
Right.
times it's not. Is there like a protocol or?
There is, and that's really a policy procedure kind of thing. And there are certain questions you can ask and more questions that you cannot ask. You can only ask a couple of different questions, and I don't have the wording for those. I wish I did. There's different types of service animals. I mean, there are a service animal, and then there's a comfort animal, companion. Service animals are covered under the ADA, and you're obligated or required to allow a person to use a service animal in your facility or business. And that typically includes dogs, and for some reason, and the logic escapes me, miniature horses are now considered a service animal
Shetland ponies are.
in the new ADA. Now, if you want to put that into perspective and make that seem not so ridiculous, if you go back and read which I've done, the arguments or the text behind the ADA. The 2010 ADA has 4 or 5 pages of text discussing the use of capsaicin monkeys as service animals and the pros and cons of that. And the monkeys were determined ultimately not to be an appropriate service animal. Okay, miniature horses are not so bad, so we'll throw those in.
But would they have a certificate with,
You don't have to have a certificate. You really can't ask for that or ask for, anything other than you can ask if it is a service animal. And that's about it. And for your employees, you should really have something in your policy about, employee manual about that, what they can ask and can't ask.
Just the other day, I saw at Walmart, they had a sign that they only allowed service animals that were wearing a vest.
I don't know that that's going to be legal. That's probably going to get challenged at some point. Most of them do, wear a vest or identification, but I don't believe it's a requirement.
They sell vests inside Walmart, so they will.
Administration person at the front desk had to deal with a gentleman, well, I'm not going to call him a gentleman, man who came in, he's not a gentleman, who virtually assaulted her. Told her that our parking lot was out of compliance, our building was out of compliance, and was there for apparently about 10 minutes giving her citing alleged citations in the law and so forth about how he was going to come back and sue us. And she came back to my office after he left, and she was very distressed. She was very upset, and it was an assault. It wasn't battery, but it was definitely an assault. How are we supposed to deal with something like that when somebody comes in and does that? Because I would have, if I had been there, I would have called 911 immediately and asked for the person to be removed and said that there's an assault in progress.
Again, that's outside of my area of expertise. But, and you may want to talk to your attorney about what you can do. I mean, I don't think that you are obligated to undergo abuse or assault from anybody, disabled or not disabled. And if it crosses that line, I would call 911 or as well. They may have legitimate concerns, or there may be legitimate issues, but that doesn't give them the right to verbally abuse or assault somebody. I know I've dealt with cases where that has been an issue, but I personally stay away from that and let my partner or an employment attorney, if it's an employee issue, handle that, or somebody else's, because that's not my expertise. But it's certainly something that, you know, it is a problem in this because it's implemented and through private litigation, because compliance is implemented through private litigation. It creates an adversarial relationship between customers and business owners, between the disabled community and business owners. You have to have a qualified disability under California and federal law in order to sue, to bring an accessibility lawsuit. The first thing that's going to be looked at is,
Are they disabled?
do they have standing?
Okay.
And that's not for me to decide, that's for the courts to decide. I'm just saying that if they're trying that. Okay.
Right, yeah, they would not be able to bring a law. They may be out looking, checking things out, and they're going to come back with somebody who is disabled. I mean, what happens is attorneys will recruit people with disabilities to go around and look at places of business and come back and bring a certain, I mean, they get paid on the number of cases that they bring in that get filed. That does happen.
Say someone hires you to come out and do a survey of the building. Is that document private, like attorney-client?
I mean, obviously, with us, it's confidential. What I recommend for clients who have those concerns, and could be a legitimate concern, is that if I do the project or do the work for your attorney, or address, you know, if you have your attorney, you know, get okay that it goes through them, it can be attorney work product. My report can be attorney work product and be privileged as attorney work product. It would be subpoenaable in a lawsuit. You would be required to disclose that, but it wouldn't be a public document for anything else. And you would not be obligated to share that with anybody else. So these reports are done as for an attorney on behalf of a business owner as attorney work product. Now, under the SB 269. In order to take advantage of that, there is a requirement that I submit a letter to the State Department on Disability indicating that a report was done for a client. It doesn't disclose any of the content or findings or anything else, but in order for you to start the clock running on that 120 days and limit your, get that, there has to be a mechanism that starts that clock, and that is the mechanism. When I complete a report and give it to you, I have to submit a letter to the state that starts that clock running so that they can.
So it doesn't bring any more scrutiny or?
No, it does not. There's nobody at the state level who's going to look at get that report and say, "Uh-oh, this guy's got a lot of problems. Let's go get him." That doesn't happen. But it is a requirement of that program. Yes.
Only at SB 269. How many stores would you need to come up and make it a reasonable day for you? Where you get the best rate?
Yeah.
I was thinking the same thing. Can we start a list, everybody put a name on a list, so maybe we could coordinate and have them come up at a certain time?
Yeah, and I'm sure other casts would be willing to do that too, because I'm not trying to sell my services, but I would, I'm typically, I'll just kind of walk you through what a typical survey looks for me. For a small business of the size that most businesses probably are here. I usually spend between 2 and 3 hours on site. If it's a smaller, really small, if say it doesn't, say, you are in a downtown area and you don't have parking and you don't have any on-site path of travel because you're in front of the sidewalk. Well, I don't have any exterior work to look at then. So that maybe it's an hour and a half or under 2 hours. But if it's got exterior work and interior work and bathrooms, a couple hours, 2 to 3 hours, and then probably 2 to 3 hours to put the report together and finalize the report. So if I can come up and if I come up to Willits and do one site, that's a day for me. If I come up to Willits and do 3 or 4, that's a day for me. So that's how I would look at it. Now, when I do a report, and most casts probably do this, not all, well, most CASI casts probably do this, not all casts do, but I take a lot of measurements and a lot of photographs. My purpose is to really document what the existing conditions are and create a recreatable report. So, because what happens in a lawsuit is sites start pointing fingers at each other. Well, yeah, your guy said it was, 34 inches to the top of the counter, and we got 34 and a half, and nobody's right. So I take photos, enough photos that I can document and recreate my survey. With it, I stand back, I take a view of what I'm going to measure, I take another photo of the tape of what I'm going to measure, and then I take a close-up photo of the measurement of the tape with the element that's being measured at the center of the photo, so that it's not offset vertically by photo distortion. And so one measurement is going to take at least 3 photos. If I'm measuring something that has 3 or 4 or 5 different measurements, there may be 15 or 20 photos for one element. A small report for a small business may have 400 to 500 photos. And I'm going to document every element that has accessibility requirements, whether it's compliant or not, so that if you ever get sued, you can show that everything was looked at, not just those that are not compliant, but everything was looked at and you've got documentation of that. Then from that, we're going to create a list of what the barriers are. I'm going to identify what the citation in the California Building Code is that relates to that barrier, and the ADA that relates to that barrier for current code. And if it takes a little more time, but probably also if you request it, for the code at the time it was constructed, so you know what the requirement was when it was constructed. A description of what the requirement is. I'm going to describe why it's a barrier, what the non-compliance issue is with that element. I'm going to give you a recommendation, at least one recommendation, maybe 2 or 3, for how you can remove that barrier, what you can do. If it's a parking lot and the slope's too great, well, it may be that we can do an asphalt overlay. So there may be 2 or 3 different recommendations for barrier removal, and then each item will list the photos that apply to that barrier by the number, so you can see all the measurements and all the issues and for it. So that's typically the kind of report I give. And then also in that table, there's going to be a column where we can identify what your decision about that element is. We're going to fix the, and we can also include costs, estimated costs, kind of planning costs. If it's replace the grab bars, maybe it's a $200 item. And so you can go through and for anything that's, maybe you say, hey, I'm going to fix all items under $200 or $200 and less, you can go through and put in the fixed column. I'm going to fix these items by this date. The other items are going to be deferred until next year, and I've got $1,000 set aside for items next year, and put those dates in there. So you can use that report to create your plan. You can kind of look at that plan, check off as you complete items, check them off. Put the date in that it's completed. It'll be in a PDF format. You can enter that, or we can give you a Word or Excel format that you can edit. I'll keep an original version so I know what it is for my records, but it's a good record keeping tool.
In your report, do you prioritize for the owner, like what's the most obvious thing that should be taken care of?
I would do that with your consultation. There are guidelines given in the ADA and California Building Code about what priorities might be. And generally, we're going to follow those priorities, but there may be certain elements or things in your business that are more important to you or create greater access or usability for your clients or customers, where we may want to prioritize things different. Or it may be a budgetary reason why, I can afford to do this year, but even though it's maybe a lower priority, I'm going to do this year and postpone something else. It may be that there are certain things that may be lower on the priority list, but because of the severity of the barrier, they create a hazard and create a greater risk of injury for somebody. We definitely look at prioritizing those higher than something else.
Gary, did you say that CalDAG's available online?
Don't know if you can purchase an online version or not, but Builder's Book Source in Berkeley has it, and you can order it online from them.
Okay.
You can also order it from Mike Gibbons, who is the author, and you can probably get that information from John.
On your top 10 myths sheet,
Yeah.
number 1 is I'm grandfather.
Yes.
Can you expand on that?
Yeah. There is no grandfathering. There's no such thing as grandfathering as it relates to access issues. So, again, like I said, there are 2 different types of triggers for access compliance. One we think about mostly is if I do a building project, new construction or alteration, I have to comply with the building code at the time. But if I bought my building in 1980 and I haven't done anything to it, well, in 1990 the ADA was passed. In 1993 it became effective for Title III for businesses. And it says that, Mr. Business Owner, you have an ongoing obligation to remove barriers at your place of business when it's readily achievable to do so. And that effectively eliminates the concept of grandfather. So there is no such thing as grandfather. Under the 2010 ADA standards, which is the most current, it's the one that we're under right now, and the California Building Code, there is what's called safe harbor. So in 2010, there were some significant changes and expansion of some scoping in the ADA. Because they recognized that might create a hardship for a lot of people, they put in a safe harbor provision. And that says that if your facility or building was compliant with the 1990 ADAG, the previous requirements, then you have safe harbor status under the 2010, the new requirements. And you do not have to upgrade or comply with the new requirements for those elements that were compliant already. Even if you're doing an alteration project and you're not touching those items, even let's say you've got elements in your bathroom, So you have elements in your bathroom that were compliant with 91 that are not compliant with the current standard. If you're not touching those as part of your alteration, you don't have to bring it up to the current standard, even if that bathroom is triggered as part of the path of travel obligation for that alteration. The only time you'd have to upgrade that bathroom would be if you are doing that bathroom, if the bathroom is the scope of work. Say you're gutting the bathroom. You've had a big plumbing leak, and you've had to gut the bathroom. Then the bathroom becomes your area of alteration, and that has to comply now. But if otherwise it does not, you have safe harbor under the new code. Now, California Building Code has the same provision, but because California Building Code updates every 3 years on average, the building code says that if you were compliant with the previous edition or previous building code, then you have safe harbor. That was really good up until January 1st of this year because the previous building code was pretty much in compliance with the previous ADA requirements. Now the California Building Code, the current edition, you can go back to the previous one, but the previous one was more restrictive than the one before that. So there's the safe harbor provisions under the building code are not so great anymore, but from an ADA point of view, if it's an ADA issue or an ADA lawsuit, you still have safe harbor from that point of view. The ADA is where the trigger is going to be for a lawsuit. So even though your bathroom is not compliant with California Building Code current or the previous California Building Code, that doesn't matter. If you were compliant with the original ADA, that non-compliance for building code cannot be the basis for an ADA lawsuit. So from that point of view, it's still really good.
So we're at almost 10 after 8. We allotted 2 hours for this presentation. I don't know if you've covered everything you needed.
No, I think we got it all through the Q&A, so that's
Um,
better than the slides.
Yeah, a lot of information covered in a short period of time, probably just scratching the surface, but I think that it's piqued all of our interest in getting more information, and City and the Chamber will work together to get more information out to you with links to Cassie, and on that, I've been to that site, it's excellent. There's information about inspectors throughout the state.
Yeah.
So
Yeah, there's a good list there, so I'm not the only guy,
Yeah.
so.
And a lot of good resource information, just if you want to do kind of a self-teach thing, there's a lot of good information. Gary, thank you so much. This is a